SJC-11720, Commonwealth versus Barbosa.
Thank you.
Good morning.
Good morning. May it please the court, Patty DeJunas for Jason Barbosa. As you may recall from the brief, no one else was arrested or charged in connection with the murder of Anthony DePina. Until just shortly before trial, the Commonwealth was proceeding as this were just a single shooter theory. When they got more information about the GPS evidence and that it showed that the defendant was 50 feet away, at least 8 seconds before the shooting occurred, a new team of prosecutors was brought in, a new so-called expert was brought in, and the case morphed from a single shooter theory to a single shooter theory plus an undefined member of this killing team. So because these are mutually exclusive theories, he could not have been in both places at the same time. He was either the shooter or he was the decoy. There's no confusion as to what the possible roles could have been. There's also no evidence that any of the other alleged co-venturers were there. So it's not as though the jury could have been confused as to what he did versus somebody else did. He was either in the alley or he was in the street. And so with that, I'd like to start with the sufficiency of evidence argument. And I thought it made sense to go through sort of chronologically the highlights of what the evidence is.
Well, with respect to the GPS evidence, at least I thought I read the Commonwealth's brief to be saying that, and I don't know what the evidence was at trial, but that it was not entirely, I understand about the 50 feet, but that there was some possibility that it wasn't tracking, or whatever the verb is, in the alleyway, that it wouldn't be as successful.
And there was evidence to that effect. There was also evidence to the effect of when they tested that theory that it wouldn't, whether or not the GPS would register, what happened was there was a canyon effect. The GPS indicated that the signal was bouncing. There's no indication of that for the missing GPS coordinate 23 seconds after the murder. There's no interference before, there's no interference after, there's no hint of a canyon effect as the kind of experiment had revealed. The other thing is that we know for sure where he was about 8 seconds before the shooting, and he was at least 50 feet away down Burrell Street. We know that Maria was looking in that direction when she heard DePina say, "Are you for real, little J?" And she looked, and there was a man who matched his Mr. Barbosa's description. And she looked at him, the shots were fired, and she ran. At that same moment, the shooter ran out of the alley, either to fire the shots or after the shots were fired. So, and keep in mind that one of the bases that the judge allowed in for real little J was it was a statement of identification. So she let it in because Mr. DePina was looking at this person and said little J. So you would have to ignore pretty much everything that Maria said from the time that she approached the car just before the shots were fired in order to conclude that Mr. Barbosa was in the alley. So, you know, is it conceivable that he could have run the 50 feet into the alley in those 8 seconds? Maybe, but could have.
Isn't that the point, that there's circumstantial evidence to show that he could have been the shooter or a decoy, and so if the jury could find either one of those, it's okay?
But there's no evidence that he ran to the alley. There's evidence that Maria was looking down the street. She saw somebody with short braids. She believed it was Mr. Barbosa, and she looked at him. DePina said, for real, little J, the shots were fired, the man was still in the street. So,
Why do you say the man was still in the street when the shots were fired?
because it happened within a second. For real, little J, shots fired instantaneously. And so when DePina said, for real, little J, Maria's attention was drawn to the man in the street. The man in the street in that second could not have run from that location to the alley to fire off the shots and then get back to the car and be on Marshfield Street a few seconds later.
I have sort of a big picture question before you get into the minutia. This is a post-Zanetti jury instruction,
Yes.
right? So before you tell us why there's not enough evidence as to principle, why does it matter?
Well, it matters because in Commonwealth versus O'Cara and Commonwealth versus Miranda, even in Zanetti itself, says that the judge's duties as to make sure that convictions are supported by sufficient evidence it doesn't disappear under Zanetti. And so what O'Cara says is that if the Commonwealth has two mutually exclusive alternative theories of joint venture, that the conviction can stand only if both are legally sustainable. So if he cannot be the shooter, then he's at a minimum entitled to a new trial. Now, but I also argue, and we maintain strongly, that there's not enough evidence of joint venture either. So this court has not yet reversed a conviction on joint venture with mutually exclusive theories, but O'Cara and Miranda certainly, and even Zanetti says that that should be done, where it's an either or, and they didn't prove one. And here, it's not just an either or. Here, you have the Commonwealth who's arguing principle or joint venture. The judge incorporates that into her instructions. The Commonwealth argues in closing, you don't all have to agree. The judge instructs in closing, you don't all have to agree. So what you have here is a jury that's being invited to either convict because he's a shooter or to convict because he was a knowing participant other than the shooter. So, and it's a general verdict. We don't know on what ground they convicted him of. And so, because if he cannot be the shooter, then we're in a situation where we don't know if some of those jurors had convicted him on that basis, because both were presented and they were told that they didn't have to agree.
But you obviously agree that if, in the light most favorable to the Commonwealth, there's enough on principle and what we used to call joint venture, that under Zanetti it doesn't matter, and those instructions were correct and the argument was correct.
Well, I'm not challenging the instructions. I'm not saying that the instructions were incorrect. I'm saying that given the way that the case was argued and instructed and the mutually exclusive theories, that when you take all those into account, that both have to be legally sustainable. One rational juror would have to be able to find beyond a reasonable doubt that he was the shooter. Another rational juror would have to be able to find beyond a reasonable doubt that he participated in a different way with the shared intent to kill. And so the shooter had to have been in the alley. That's undisputed evidence that the shots came from the alley. It's undisputed that the video shows that the shooter's legs run out of the alley either as or just before the shots were fired. Maria's looking down the street at somebody who looks like Mr. Barbosa. The GPS puts him there. So is it theoretically possible that somebody could run that far in 8 seconds? Maybe, but there's no indication that he did. You have to assume that he's the shooter in order to say, well, he could have gotten to the alley, therefore he's the shooter. But you have to first presume guilt in order to get there that way.
Now, the evidence of where he was is solely from the woman who was with the victim at the time?
Also the GPS evidence.
Well, that's, though, intermittent. I mean, that's 8 seconds before and then 22 seconds afterward. I mean, 50 feet's not that far. You can do it in 8 seconds.
Well, you could, but there's no evidence that the person in the street ran that far.
Right. I mean, and that's
so,
what I'm asking. There's no evidence because that's not what, I forget the name of...
Maria.
Was it Maria? That's not what Maria testified to, or was there other videos that would have shown that?
No.
The reason you saw feet leaving the alley, was that from a video?
It was from the surveillance video from the bar.
So there was a surveillance video from the VAR that spotted that?
Yes.
But would the surveillance video have spotted somebody running from the spot where Barbosa supposedly was to the alley?
Well, you could certainly see the entrance to the alley, and you see that Mr. DePina and Maria walking to the car, and you don't see anybody coming. You only see the shooter leaving. The other thing is, the shooter left the alley. So there's no reason for there to be a missing GPS coordinate 22 seconds after the shooting.
Well, just going back for a second, with respect to what Maria heard and saw, what was the evidence in terms of how close to is this for real little J and the shot?
Within a second,
In
instantaneous.
a second? And didn't she run instantaneously?
She ran when the shots were fired. She heard the shots. She said that that she thought that her boyfriend had gone down to the ground, but she didn't know that she was shot. She ran this way. The shooter's legs, you could see Maria's legs first, and then the shooter's legs, but it's within like microseconds. You see the two fleeing. I mean, it's just, there would have to be somebody who looked just like Mr. Barbosa, and it's not any of the supposed co-venturers, because they don't have the same hairstyle that he had. They didn't have on the same shirt that he had. And so you've got Maria who knows Barbosa. She says, I believe it was him, but I couldn't see his face, but I wasn't sure. And the judge let in the statement for real little J, because the judge said that it was an identification of the person in the street, which is where both DePina and Maria had been looking.
Well, okay.
Is this alley a dead end?
Is it a dead end? I don't believe that there's evidence of that in the record one way or the other. But again, so that would, if it was not a dead end, it would require him to have run around the block in 8 seconds, come out, and still who's in the street that Maria's looking at as the shots were fired. There's no explanation for that. There's no evidence that any of the other co-venturers were there. The black Cadillac that Manny Montron was driving was last seen about 8 minutes before the shooting. Contrary to what the Commonwealth says in its brief, there's no evidence that he followed Mr. Barbosa from the scene of the shooting. The other people involved had not been seen in the vicinity for even longer than that. So, the notion that he was there, is knowingly participated in the murder with the shared intent to kill, there's no evidence who was there, who was in the alley. We know it could not have been Mr. Barbosa. There's just too many, and you don't even have to speculate. It's impossible, because there's nobody else that it could have been in the street. And if he had run, fired off the shots, then you would have seen him on the video. And then you see the shooter leave, well, then he would have had to go right back into the alley in order for the missing GPS coordinate to make sense. And there's no evidence that that happened.
I'm sorry to be slow on the uptake on this. The Commonwealth is going to tell us why there's sufficient evidence that he wasn't the shooter and sufficient evidence that he was. But is there any post-Zanetti case that says, ladies and gentlemen, if you find beyond a reasonable doubt that the defendant was either the principal or was there as an accessory, recognizing that there's no distinction in Zanetti between those two, but was either there as the shooter or there to assist. If all 12 of you agree with that beyond a reasonable doubt, you should find him not guilty if you don't know which one. Is there any post-Zanetti case that says that?
Well, no, I don't think that that's what I'm arguing, but there are two post-Zanetti cases, Miranda and Acara. And again, if you look at Zanetti itself, it says judges, their role to make sure that that evidence are supported by sufficient evidence is not abdicated because of the rule of Zanetti. And in Acara, it was a situation where this court said the best theory against both defendants was that each one was the shooter. That's impossible. There was only one shooter in that case. And so, the court said if one theory is not sustained, then we would have to reverse. And in that case, the court didn't reverse because there was some sort of confusion as to, both the co-venturers were together before and during and after. And so there could have been, some jurors could have said, oh, well, co-venturer one handed the firearm to the other one and he shot, and another juror could say that, oh, well, this one gave the gun to that one and he was the shooter. And because of sort of the confusion as to what their roles were, the jury could also infer beyond a reasonable doubt that if he wasn't the shooter, that he was there to assist the person who was the shooter. And here, there's none of that. I mean, he was either, he couldn't be in two places at once. The shooter had to be in the alley. That's undisputed. I don't think the Commonwealth can challenge that. I'd be surprised if they did. So it's...
So your theory is that your client is walking towards the victim for no apparent good reason.
walking towards the bar that he was a regular at, and that the bartender testified it was common for people to, including the defendant, to come and go throughout the evening. So it's not, he was headed right back up to the street to the bar. This wasn't a random place.
But I thought he was walking in the middle of the street.
He was walking up the street towards the bar. So Chin's bar is here on this corner. Mr. Barbosa was here, and the victim
He was in the
his car
street
was
as
here.
opposed to on the sidewalk? He was in the street as opposed to on a sidewalk?
I believe that was the testimony, that he was in the street.
So he's in the street walking toward, the bar's here and the victim's here, and Barbosa's walking either towards the victim or towards the bar. We can't really
Right,
tell.
and it's a one-way street.
And at the very moment in which he says
Is that for real, little
something
J?
about little J, I
Is
forget.
that for real?
for
Are
real
you
Are you
little
for
for
J?
real, little J, that as a matter of coincidence, for reasons unrelated to the presence of Barbosa, shots are fired from somebody laying in wait in an alley?
Well, we don't know what prompted him to say "for real, little J." Maria didn't say, and there's nothing on the video. So for the court to infer that he did something to distract him, you're just speculating as to what that would have been. You're also speculating as to who was in the alley, because, like I said, there's no evidence that Montrond or Lopes, the only two alleged co-venturers that the Commonwealth named, there's no evidence that they were there.
What are we to make of the defendant's statement that you don't belong here? Where does that fit in your theory?
So I think the statement is not as clear. I think it wasn't, there was some confusion as to what was said. It said when DePina comes back with Joe Rosa, who is a senior Wendover gang member, and so there's some testimony that he said, "You guys don't belong here."
Or
and
you shouldn't be here?
Or you shouldn't be here, along those
So
lines.
the precise words don't matter. It's the point that he's pointing out that this is our territory. So what are we to make of that?
Well, I'm not sure how much you can make of it, Your Honor, because DePina had been there earlier that same evening. He was a regular there. He always went to that bar. He was friendly with the defendant. The bartender said he was a regular there, DePina was, that he often saw my client and Lopes and Montrond having friendly interactions with him. So the fact that this was said, if you could infer that it was a threat, and I don't think that it's clear that it was, but if you could infer that it was a threat, it doesn't mean that it was carried through or that it was to murder. If you type back to the motive evidence, which is this gang retaliation, right?
Well, the people who heard the defendant say that thought it was a threat. The judge allowed them to testify to that. And so the jury would have assumed that the defendant was saying, "You'd better get out of here or else." And the victim didn't do that.
If it was a threat, that doesn't mean that it was a threat to kill. Because if you go back and refer back to what the retaliation evidence was that there had been an altercation between my client, Lopes Montrond, Angelo Texera, who is the leader of the Wendover
But we
gang.
don't look at that in isolation. I mean, it's part of the whole silent movie, as it were, that he says this, and you've got all of this backdrop of what happened a couple of weeks before or months before at the gas station where your client was shot, apparently.
The jury didn't know that. All the jury heard was that he was injured. There was no evidence that it was
Okay,
a
well,
They
he's injured.
heard it was
So
an
he's injured.
incident involving
They
Angela.
did, and so they heard that he was hurt. I don't think that you can then infer from "you don't belong here" that, and don't forget, Mr. DePina wasn't at that incident. And the beef is between Jason Barbosa and Angelo Texera. And so Anthony DePina is not there.
Right,
So
but
to then infer that he said, "you don't belong here," to infer from that an intent to kill, when the jury only knows that there had been an injury and that DePina wasn't even there and Angelo Texera wasn't there, I don't think that that's a logical or rational inference. Even if it is, even if you could say that was a threat, that's not enough to show that he was involved in the killing. I mean, just like
Well, he's there. I mean, I realize that being there is not enough, but he's there, and he says, "You don't belong here," and a few minutes later, or a few seconds later, the shots ring out.
it was about 8 to 10 minutes later, I
Okay.
believe. So I don't, you still have to show what he did to knowingly participate. He couldn't have been the shooter. The GPS and Maria's testimony shows that. So even if he threatened him, it doesn't mean that he killed him. Just in Gonzalez, this court said you could have the motive, and the jury could infer that that motive impelled you to murder, and you could have consciousness of guilt, and that doesn't prove joint venture beyond a reasonable doubt. There still has to be some evidence of something that he did to knowingly participate in the shooting, and there's none of that. He was there. That's it.
All right.
I see that I'm out of time. If the court has any questions,
Thank you. Ms. Anderson, still morning. Good morning.
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. With me this morning is Assistant District Attorney Patrick Hagan, who tried this case. Your Honor, we're asking this Court to affirm the defendant's first-degree murder conviction for the death of Anthony DePina. Here, the jury heard sufficient evidence that the defendant was an integral participant. In fact, he was...
could you focus in on the actual GPS, and also another question that Mr. Junius raised was where Montrand and Lopes were?
Certainly, Your Honor. I'll
The other
start-
car, the Cadillac.
Certainly. It's the Commonwealth's perspective, based on the video evidence, that after the murder, the Cadillac follows a small SUV around the corner, as it had numerous times that evening. I think
So
another...
we know the SUV is next to, I forget his name, the senior member of DeRosa.
Joe Rosa, an earlier part of that evening, correct?
Yes, and that's when the "you shouldn't be here" comes out, right? And so take me from there. The
Certainly.
decedent goes to the bar and then comes out again, right?
Correct. If we're going to put all the facts together, we have to go back a little bit further. But going from there, "you don't belong here" is the threat. This comes after the defendant goes in and searches the bar. This comes after the defendant goes to Maria Texera's house. This comes after the defendant walks down the street far enough to where the victim's car would have been and then turns around and leaves. So there's been multiple searches and stalking that has occurred prior to this point. Prior to the threat even being issued, the defendant's behavior is indicative of this intent to kill. Here, the defendant issues the threat, "you don't belong here." It is the defendant, only the defendant in the car, and it's the GPS in conjunction with the bar video. It's one of those points where we can determine that the bar video is approximately 4 minutes and 36 seconds faster than the GPS. So what you can see is there's a GPS point that registers at a specific time based on the atomic clock and is certain and is correct. Then you can see on the video where the defendant is. And so that's how we are making that calculation. It's subject to some seconds here and there, so that's where I think when we talk about 8 seconds and whether things are possible, we can't get bogged down in those small details. And again, the GPS there's testimony that it's accurate to a point of 15 feet. And so that's another consideration that we need to have here. It's a long-winded way of saying after the threat is issued, the Cadillac follows behind. and circles the block. After that point, the defendant comes back around and makes one final pass by the bar. I think this is another point, again, we're demonstrating the defendant being instrumental and integral in this joint venture. The victim is standing outside having a cigarette while Maria goes inside to use the restroom, and presumably they're going to have another drink at the bar. At that point, the GPS data and the video show the defendant traveling by on Norfolk at approximately 11 miles an hour, and that's consistent with the video showing a small SUV, a car, driving by, and you can see in the bar video the victim pointing at him. And it's at that point that the victim's intention changes. Within minutes or seconds, I think, he goes into the bar, sits in the bar, says he doesn't want to drink, and waits for Maria to come out. When Maria comes out, he tells her, "We ought to go. It's time to go." And that's when they walk down Burrell Street to the car. Their car is parked the wrong way on Burrell Street, and so it's the driver's side that's up against the sidewalk. And at that point, Maria is going to the passenger side. So when the victim says, "Are you for real, little J?" which again, I acknowledge that has a host of meanings in any normative context. It might be something I would say to a friend, "Are you for real?" But it's in this specific context, it's identifying who is responsible. Are you for real, little J? Whether that little J, the defendant, is the person standing in the middle of the street that Maria sees, which is entirely possible based on the GPS evidence, or whether it's someone else standing in the middle of the street who looks like the defendant while the defendant is in the alley at that time and he is the shooter. I'd point the court to the Commonwealth's appendix, pages 65, has a picture. It's Exhibit 87. This is part of the prosecutor's closing argument PowerPoint. But there's a picture in the appendix of Manny Montrond as one photo. There's also a picture of the defendant at the Commonwealth's appendix, page 75. And certainly in a dark night, I think this court can see that both men have braids, both men have a similar complexion, both men have a slender type face. It's one explanation. I don't think that it needs to be conclusive that it was Manny Montrond. But again, after the shots ring out, after the shooting occurs, the Cadillac then comes around, and this is for the court's viewing. The other point I'd like to make is
After the
that,
shooting, the Cadillac comes around too?
yes, again, as we've seen the same patterns throughout the evening, the Cadillac following the SUV. The other pattern that we see earlier in the night is Manny Montrond driving the Cadillac. This is at the early part of the evening, around 9 p.m. Manny Montrond parks with Jason Barbosa in the passenger seat, and they meet up with their friend Kenny Lopes. When Lopes gets out of his own car, I think he gets dropped off on the corner, Manny Montrond flashes his lights. And that's the first time you see that. You see the lights flashing again right before the murder. On the video, there are 4 flashes. In the Commonwealth's position, it's reasonable to infer that that was a signal to the shooter, to the person in the middle of the street. I think it's appropriate to call that person a decoy. I don't think you even need to go that far and say that they were doing something to distract. There's no evidence of that. There's no evidence that that person had a weapon. There's no evidence that person did not have a weapon. But that person, if it was the defendant, was present at the scene of the crime, and you take his actions from earlier in the night, you take his actions immediately after the murder, you take the actions of Manny Montrond returning the rental car the following day, and when you add all of those together, which is a proper way to look at the case and look at the analysis, that's where you find he's ready, willing, and able to participate, and
But
he is
can you-
there and sharing the intent.
Can you give what the evidence is that he's the actual shooter? Because both of them have to be, they don't necessarily have to be as strong, but can you give the evidence?
Certainly, Your Honor. I think if the defendant is the shooter, he is not the person in the middle of the street. And so the GPS evidence would support the defendant walking at 2 miles an hour, and then there's the missing GPS point, which could be accounted for, again, in a couple different ways, one being in the alley, another being the movement threshold that he didn't go the requisite 30 feet. The end of the alley, as the jury saw on the view, has a small fence, so it would be possible for the shooter, the defendant, to walk down Burrell Street, go into the alley, do the shot, commit the murder, and then go through the alley. It would also be possible to go back up the street, and that would perhaps account for that movement threshold. If it's from the point where you start, if you go 30 feet out, if you go 40 feet out and come back 20, you're within that 30 feet. And so the movement threshold would trigger and would not record that GPS point.
But is it clear that the victim said, "Are you for real, little J," to the person in the middle of the street?
No, it's not. And it's also important to note that Maria Texera does not identify the person in the middle of the street as the defendant. That certainly it's someone that is consistent with the defendant, and certainly that's her perspective of who the defendant is talking to, and he says that, but she's not looking at the defendant. She's looking at the person in the middle of the street. So she's kind of putting two and two together. I think the most important part of that statement, "Are you for real, little J," is he's talking about who's responsible in a bigger way, in a, I know what's happening next. I know who's responsible and who is orchestrating and who is planning and who has plotted and who is committing this murder.
I know it's not your view of the evidence, but if there's insufficient evidence that the defendant is the shooter, and you have a post-Cinetti situation contemplating Commonwealth versus Akara, what are the implications?
I do believe where it's the general verdict that the law of this court is that it needs to be sufficient on both principle, the old-fashioned principle and joint venture liability. I know I briefed another case that way recently, Commonwealth versus Gomes, and in my review of this court's case laws, that's the state of the law. Certainly, I don't know.
Where you have one shot and one shooter.
Correct. And where I suppose it's fair to say that they are mutually exclusive, and that's the way I'm arguing it is he is either the shooter or the person in the middle of the street. But as Your Honor notes, with the new language of Zanetti, we're looking to the sufficiency of the evidence that the defendant was a knowing participant and shared the intent. And I think we can prove that in multiple ways. It was argued to the jury both ways, shooter and person in the middle of the street. I think it would be fair to find sufficient evidence. I think it would be fair to require the Commonwealth to prove sufficient evidence on both. And I think the Commonwealth has here in this case.
I'm still a little confused about what you have that shows that the defendant was the person who fired the shot. I'm not following your factual scenario there.
Sure. The GPS is not so dispositive as to put the defendant in the middle of the street. So it's based on the GPS data allowing the inference that the defendant, it certainly proves that he's in the vicinity and certainly at right around the right time. It allows the inference that the defendant was able to get into the alley and that he was that person in the alley. It certainly is not direct and conclusive proof, but it is reasonable to infer. The detectives in this case also investigated the Chin's cameras, and they are movement activated. And so that was another point that the Commonwealth presented, is that the defendant would be able to come down, or the shooter would be able to come down Burrell Street and get into the alley without triggering the movement activated camera. So I guess the theory is that it's possible and that it's more than just likely based on the GPS data. And then again, we have the whole picture put together. I think looking at that in isolation is but one piece, and I understand Your Honor's concern. But we have to start with the background, with the feud between Wendover and Woodward, and move from there through the events of the night, through at that exact moment is the evidence there, and then what followed the next day.
Is there something that was in the evidence, or there seems to be no dispute that in the bar earlier, the defendant and the victim were communicating, talking, and it seemed fine. So is there something about, with respect to the two groups, that being in the bar is one thing, being in the territory is another? Was there any evidence of that? I mean,
No, there was some evidence that each gang has its own separate bar, and that Chin's
but-
was
but-
not the bar for.
But DePina goes there all the time. or
I don't think
went-
the testimony is he goes there all the time. I think that the bartender recognized him. I think he certainly goes there. And earlier in the night, the two weren't friendly and interacting. There's a moment in the video where they greet one another, but then the victim and Maria go down to the end of the bar. And then one of the women with the defendant's group goes down to the bar with him. The two go out to the car, and there is coming and going. There's no, other than that initial greeting between the defendant and the victim, which looks friendly on the video. Other than that, there's no further interaction until the pointing. And again, I think that things have shifted by that point.
Just one other question. With respect to the Judge McAvoy's ruling about, is it Detective O'Malley?
Yes.
I couldn't tell from reading and this is all I've read, is that the ruling that she gave from the bench. I didn't read the evidence, but was she making the judgment that he was qualified to testify based on on whatever was presented in the voir dire, or maybe it was a motion, in this case, or was it, because she talked about he had testified as an expert in a different case that she had tried. And I couldn't tell where the judgment that he was qualified was coming from.
The judgment was coming from the voir dire hearing that we had here. It was extensive, I think at least a couple of hours. I think she's referencing her experience with him just to give it a little more oomph. And there was no dispute that Detective O'Malley was qualified to give his expert opinion.
I mean, at the time, at the trial.
Correct. Either following the voir dire and then at the trial. No, there was no objection as to that. And there was other evidence through civilian witnesses that aligned each with their groups.
Help me to go back to the precise moment of the shooting.
Yes,
The defendant is standing by the driver's side door, which is nearest the sidewalk?
The victim.
I'm sorry, the
yes.
victim?
Yes.
So he's standing, is the door open or not yet open?
Not yet open. I believe the keys are in his hand.
So the keys are in his hand, he's on the sidewalk, and he is about to open the door. And then, according to Maria, he sees this individual walking towards him.
According to Maria, all she can say is that the victim said, "Are you for real, little J?"
Did she see, but she saw this person,
She saw a person and describes the person in the street, yes.
and was,
He's on the other side of the car.
Correct,
and she saw him walking down the street
correct,
towards them,
yes.
not on the sidewalk.
In the street, in the
In the
middle
middle
of the street. Yes, Your Honor.
And did she describe anything with regard to his hands?
She could not see what he had in his hands. I think at some point on cross-examination, she says he does not have a gun. But there is some equivocation there versus doesn't have, couldn't see, might have.
And is the alley at a 90-degree angle from where the victim is?
Yes, roughly, yes.
So he basically is essentially at the end of the alley,
Correct.
which you say has a fence on one side?
On the far end of the alley. So one end of the alley is the street, and then there's the bar in the building, there's some apartments. So further back, if you ran back down the alley, it would be a small fence to jump over, and I think that's Marshfield Street on the other side. It simply being conceivable, there was no evidence that the shooter did that.
Right. And the margin, was there evidence as to the margin of error of the GPS bracelet?
15 feet.
15 feet. And the margin of error as to time?
I believe is approximately 15 to 20 seconds. And I was the one
Oh, that-
responsible for those calculations.
What does that mean?
That much?
Yes,
So what we say 8 seconds before, it could be 23 to,
yes. The calculation for the time is based on looking at one GPS point versus what you can see on the video. And so you can see that the defendant is
And then taking
stopped.
off 4 minutes and 36 seconds, or whatever it was?
Well, to come up with 4 minutes and 36 seconds, you look at the video and you look at one GPS point. So for example, when the defendant threatens, "You don't belong here." When you see the video, you can see there's I think, about a 15-second period of time where his car appears. And during that period of time, there is a GPS point. That GPS point could have occurred at any point in that 15 seconds. So it could have been right when he stopped, the GPS was taking. It could have been at the end of that period that the GPS was taking. So that's where you come up with, again, there's a range of seconds, and then there's a range on the GPS itself.
And in terms of figuring out where within the 15 seconds, do we view it essentially as a curve in which the most likely is the middle?
That's what I did, yes, Your Honor.
Okay, so you basically view it as a bell curve, and you took essentially the middle of the bell curve
Correct.
as your estimate of time.
Correct.
So
Split
when
it
you
straight
say-
down the middle.
So when you say 8 seconds, 8 seconds would be the bell curve, and on one side would be 23 seconds, and the other side would be 4 seconds before.
Yes. There's a margin of error there. And again, the GPS gets us only so far. It gets us a great distance there. But it cannot be looked at in isolation. If all that I had today standing up in front of Your Honors was this GPS, I don't think we'd have an indictment in this case. Your Honors have no further questions?
All right, thank you, and we'll take our
Sounds
morning
great.
break.
Thank you.